when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of this law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
Actually जब वो CMAs थी full court के लिए जब आर्ग्यू हो रही थी तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए this matter should be heard by a lesser number. वो CMA की वो hearing पे नहीं गई,
But the burden at the end of the day was on us.
The question was in fact put by me, and so therefore it's not that the question was not there.
My Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशिप पढ़ने के बाद महसूस तो कि जब ये पिटीशन दी गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड हुआ था, जो कि आज तक इनफील्ड नहीं है. अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता. इसका मतलब ये कि हम एक्ट को मान रहे हैं. अगर हम बेंच पे एतराज कर रहे हैं इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते, व्हाई नॉट फुल कोर्ट.
So मैं इसका brief response दूं and then followed by a detailed response in writing, briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench.
Mr. Attorney General, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती.
In cases, in circumstances, हो सकता है जैसे अभी भी है.
प्रकाशन तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से.
So let me put it differently. Now
फुल कोर्ट कभी बैठ ही नहीं सकती.
फुल कोर्ट आप बैठेंगे
in Article 184 questions which are the most important question that can ever be raised before the court.
In exceptional circumstances, it might be so. But does that is that to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to have the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time it will be saying that it's so important that a collective wisdom will prevail. There is no, I mean, doesn't really, it can be easily
It can be reconciled. My Lord, Section 6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when situations this sort arises, that be so, my Lord.
Right of appeal पे substantive right नहीं है, जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not. And all of that has happened under 184(3). With great respect. With great respect. And Steel Mill is a classic example. Steel Mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly bleeding.
How many of those were full court? Those were full court judgments.
My Lord, may not be.
यही तो मैं आपसे कह रहा हूँ ना.
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
साहब यही तो point है कि एक तरफ आप कह रहे हैं हम right of appeal दे रहे हैं in order to address precisely these kind of things. दूसरी तरफ कह रहे हैं चलो full court बन जाए तो बन जाए.
Full court बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप kindly जरा थोड़ी सी.
There might be issues in time.
Implications of your submission तो kindly
मैं उसको ये इस तरह से आपको कर देता हूं कि आप ये बैलेंस आप रख
Attorney
लेंगे।
General Saab, we are all grown-ups, right?
Attorney General Saab,
Can I just, the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say there has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. Okay? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we are about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did Rekudik. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction, we have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary, they'll say, what are you talking about independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy, we don't understand the repercussion of things. Fine, I'm not saying that judges who decided that, they did what they thought time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, the repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review unanimous because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस legislation की भी ज़रूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा problem ये हो गया ना, अनबड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं. मान लें गलतियां हुई हैं, ठीक है, हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है, ठीक है, अदरवाइज आइन की कोई हैसियत नहीं है. अगर जज मेड लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. द मिनट आई से दैट प्लीज फाइल अ against me that I'm violating my oath of office if I say even this, कि I will endorse these subsequent acts. तो हमें मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं बताया उनको क्या मसला हो रहा है, उनको हमारा फिगर पढ़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? Why are we waiting for him to bring an act? 10 petitions आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं, वो कहते हैं हमारा केस चला के. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. But what are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें Attorney General साहब, law reforms ordinance के तहत there's a right of appeal. लेकिन कई cases में, depending on the issues, the high courts constitute larger benches and therefore that right of appeal is not availed. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है 184.3 is discretionary. Now यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज है वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This will just like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under section
provision
7.
of intra-court appeal, that is to be seen. Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
पाकिस्तान की तारीख में पहली दफा फुल कोर्ट समाअत सुप्रीम कोर्ट के 15 जजेस समाअत कर रहे हैं, जिसको बराह रास्त अवाम तक पहुंचाया जा रहा है. न्यूज़ स्टूडियो से अब तक के लिए इतना है.